In our last video, we talked about Blake's causes of action. Specifically, we talked about jurisdiction, or which state law was going to be applied to her case. There are issues. We're following up on Jed Wallace. Jed Wallace, who managed to escape momentarily, only to be drugged back in by Blake. The biggest fight between them at the moment is that Blake wants his case, like all the others, wrapped up in New York. He says, heck no, I won't go. I'm staying in Texas. But the plus side is, we get to continue to hear from Jed Wallace's attorneys, who are by far the most entertaining in this entire lawsuit, especially Mr. Babcock. And he's in rare form today. He starts with lyrics from Taylor Swift, and he ends with lyrics from Elton John with a cute little quip. We're going to talk about New York's long-arm statute. He says, like the seasons, Blake Lively's efforts to retain jurisdiction over the Wallace defendants are ever-changing, from a conspiracy-based theory of jurisdiction asserted in spring, but rejected in the summer, to now, in the fall, a novel theory that Lively had not raised in her prior complaint, but which is now the primary focus of her argument, specifically that Section 302A1 of the New York long-arm statute confers jurisdiction. Really, he's just so poetically calling out what a mess her claims are. They are ever-changing like the seasons. She came in with one idea, as he said, rejected it, and now there's a novel theory, a brand new theory that she'd never raised before, and it's the primary focus. And it really shows that her attorneys are just flying by the seat of their pants. This statute, this 302, is what we're going to deep dive into. He says the change is likely explained by Lively's inability to overcome her pleadings and sworn testimony that the two claims against the Wallace defendants sound in defamation. We'll learn what that means, and thus the conspiracy theory of jurisdiction found in sections 302A2 and A3 is inapplicable. Her two-paragraph attempt in a 31-page brief to overcome the defamation exception is hardly a response at all. This is another very colorful jab basically saying you have 31 pages of nothing and only 2 of the paragraphs are you attempting to overcome this exception. And here comes the Taylor Swift lyrics from Red. The colors in autumn are so bright just before they lose it all. And this one line is so powerful because not only does it allude to Taylor Swift and the lost friendship, but he's saying here she comes with this 31-page brief, their brand new theory, this primary focus. It's so bright, like autumn, and she's just about to lose. So for all its bright colors and novel excitement, it's not going to fare any better in court than her previous arguments that failed. And another just glorious one line. And the change of seasons has not cured the novelty or inapplicability of her A1 argument. So let's talk about what all this means. This section 302 that he's referring to is CPLR. That is the Civil Practice Law and Rules of New York. This is the statute that they're attempting to use to pull Jed under New York law. They're saying that his activities, none of which took place in New York, call for this statute to be put in place. Now, I've not been feeling well the last week or so, but I did go through Michael Gottlieb's motion where he tried to argue for this statute. It was long, it was exhausting, it wasn't the slightest bit entertaining. It was quite painful, in fact, to read. The mental gymnastics that they did were some of the worst I've seen in this case that's been full of mental gymnastics. I don't know if you all punished yourselves by reading it, but in it, they claim that Jed Wallace did business through conspiracy in New York. And several times he put the wrong date. He kept putting 2025 as the date that these things happened. And while I was reading it, it was such a mess that I came to the conclusion again that everybody hates Blake Lively, including her husband and including her attorneys, who are happy to keep taking her money. But the disservice that they do her from their terrible skills, if she were a nicer person, I would feel sorry for her. Because they really should have done a better job before the lawsuit was filed at explaining all of this to her. Now, her pro hoc vice attorneys, you could understand that maybe they were unaware of all of these things that happen in New York. But for Michael Gottlieb, there's no excuse. He's a New York attorney. But one thing that became very, very clear to me in all of this is that she made a huge mistake not filing this in California. for so many reasons. Several of those reasons we're going to touch on today, and they're things, as I said, a New York attorney should be very, very familiar with and should have guided her better than this because of the decisions that they made from the beginning, including choosing New York to file the actual lawsuit. Her case would be surviving so much better in California. Now, what this Section 302 is all about is jurisdiction and acts of non-domiciliaries. These are people who do not reside in New York, and none of the Wayfarer parties do. So the mental gymnastics come in with trying to attach them to New York from a business standpoint. Because with this long-arm statute, a New York court can reach non-residents if, and first we have 4 distinct rules that allow it. So if they're doing business in New York, if they commit a tort in New York, which sounds like, hey, this might be on Blake's side, but hold that thought. The third point, and I made this chart directly from these rules here, so they coincide with the numbers there. So 3, if they commit a tort outside of New York that causes injury in New York. And this is another thing that Michael Gottlieb grabbed onto. But this has 2 qualifiers. And the 4th one is own property in New York. That's not used as much. It's usually used when that specific property is at stake. So we're going to step back to number 3 first and look at these 2 qualifiers. So you can't just say, well, Blake lives in New York and so that's where her injury took place because of 2 things. These qualifiers, the first one, does business in or derives substantial revenue from New York. This right here rules Jed out. He doesn't do business in New York and he doesn't derive substantial revenue from New York. Also expects or should reasonably expect the act to have consequences in New York. This is another one of the instances that they bent over backwards with the mental gymnastics to try to prove that Jed Wallace should have known that the consequences would have occurred in New York. This is where my absolute favorite piece of evidence in this whole mess comes from. The picture of Blake standing in the room where she tries on multiple floral outfits to pose, to show off her designer clothes, to supposedly market this movie about domestic violence. In one of those pictures, she's wearing jeans, and every time I hear it, no matter how many times I hear it, I get a little embarrassed for her. In her Instagram post, she says, "Blue jean baby, New York lady." They took this picture and claim because Blake posted this picture on her Instagram that Jed Wallace should have concluded that Blake resides in New York and that his alleged acts were going to have consequences in New York. And that's their biggest piece of evidence. But keep this chart in mind because this is what Blake's team is using as saying that Jed falls under this statute. So because these are the requirements, they're going to try to custom fit Jed's situation to prove that he falls under this section. And in this response, they're considering why this isn't so. So the whole document revolves around this chart right here. Besides of these other qualifiers, points 2 and 3 come with exclusions. Looking at these rules a little more closely, we see number 2 commits a tortious act within the state, except as to a cause of action for defamation of character arising from the act. Very clearly excludes defamation. What about number 3? Commits a tort outside New York causing injury in New York, except as to a cause of action for defamation of character arising from the act. Could it be more clear? The only 2 of the 4 that they could sort of apply to Jed have the defamation exception. So this is the other hurdle that Team Blake is trying to overcome, this defamation exception. And we'll see that phrase used in this document. New York, as we learned when Justin attempted to sue the New York Times, the protections they have in place against defamation. If you remember, if you followed me back then, we talked about this, that New York protection for defamation, specifically built around cases involving the New York Times, go beyond the Constitution. The Constitution is the strongest protections in the nation, but New York goes beyond the Constitution to protect free speech. Now, you can't apply this just for the New York Times, so it gets applied across everybody. And so because defamation is so difficult to prove, they've also put so many protections around the meaning of actual malice that it's basically impregnable in New York. Another huge mistake that Blake's attorneys made. Other states, because of how difficult it is, they have, and we covered this in last episode, they've added torts that are similar to defamation that aren't quite as difficult to overcome. So what does New York do? They say, that doesn't apply here. So in last episode, we went through why her false light cause of action is going to fail in New York. New York has never allowed it, even if they're applying California law, which is what she wants them to do. Because California allows false light, New York, even if they're applying California law, they will not recognize false light. New York aims to avoid chilling speech. So all of these things they claim are chilling speech. So basically, you cannot get jurisdiction just because a story or post written elsewhere hurts your reputation in New York. New York's high courts say that defamation gets separate treatment. All the other torts, they apply, but not defamation. And they put this in place, they say, to prevent disproportionate restrictions on free speech. Now, Blake's team's demanding that their false light claim and their aiding and abetting claims that they filed against Jed Wallace shouldn't be excluded. Why? Because they say so. Now, this next paragraph sounds like a big old word puzzle, so let's break it down. But Team Wallace is saying the defamation exception forecloses jurisdiction. You cannot have this jurisdiction. A defamation claim is defined in terms of damage to reputation. He cites this case from the Southern District of New York, and this is just one of so many. New York law considers claims sounding in tort to be defamation claims, where those claims seek damages for injury to reputation, or where the entire injury complained of by plaintiff flows from the effect on her reputation. And these are precisely the claims that Lively alleges here. So let's talk about what some of this means, because some of it, like I said, sounds like a word puzzle. What does, for example, sounding in tort to be defamation claims, or sometimes just says sounding in defamation? It also mentions seeking damages for injury to reputation. The entire injury flows from the effect on her reputation. We're going to look at what all of this means. I had to add Taylor because he started with her lyrics. And if you're not a Swiftie, she has a song called Welcome to New York. And I felt like it was just perfect here because Blake filed in New York, and now she has to deal with this pesky New York law. Now remember, when I was saying that New York does not recognize false light, I said New York seems to think they're not just their own country, but they think they're their own planet. Well, here's where it sucks for Blake that she filed in New York. They have rules that are pretty exclusive to New York, and this is one of them. So sounding in defamation, it's kind of like this. If it looks like a duck, quacks like a duck, walks like a duck, it's probably a duck. That's what sounds in means. If you're claiming damages to your reputation, if your injuries are all based on your reputation, then no matter what you call this tort, you can call it whatever you want. In New York, it's defamation. It's specifically put there because of these other torts to prevent a plaintiff from attempting to bypass the strict defamation rules that they have set up by simply relabeling their claim with a more general tort like negligent infliction of emotional distress or false light. New York's like, we see what you're doing here, but it's just a duck. So, if a plaintiff is specifically asking for money to compensate for their damaged reputation, no matter what it's framed under, the court says this is about reputational harm, this is defamation. Even if a plaintiff doesn't use the word reputation specifically, the court will look at the facts in the case. If the damages are emotional distress, financial loss, and they're a direct result of false statements that hurt the plaintiff's reputation, the court will say, it's a duck. So basically, in New York, you can't sue for general harm resulting from someone's damaging words without following the stricter rules for a defamation lawsuit. The court will see, no matter how you frame it, no matter how careful your words are, the underlying issue is about those things I told you we were going to look at. What is your claim of harm? If it affects your reputation in any way, it's defamation. You can't pass it off as a simple tort. New York says, we're the home of the New York Times. We hate defamation lawsuits. So no way are we going to let you take the easy way around the lofty standards of actual malice for defamation. You can't disguise your duck. It's a duck. Blake's attorneys should have warned her about this, especially Mike Gottlieb, who, funny enough, is the one who wrote the 31 pages of nonsense trying to get around this. And then they turn to quotes from her actual complaints, where she has said, these are my damages, these are the things that Jed Wallace did to me. And what do we see? We see retaliation campaign. What's New York going to say? It's a duck. They created, seeded, manipulated, and advanced disparaging content. New York's going to say it's a duck. Devastation to her reputation. Participated in a campaign to discredit and bury her reputationally. Publicly made false and misleading disclosures that harmed her reputation. She seeks to redress alleged So they point out her allegations show that she seeks to redress alleged reputational harm caused by false statements. It's a duck. No way around it. No way she's going to fool New York. And they continue quoting from her in the footnote all of the words that she used. So not only did her attorneys not advise her against filing in New York and having to overcome this, they didn't even try to disguise their duck. They used all the words that scream out, this is defamation. And so with all the confidence in the world, Babcock proceeds with the rest of this document because this is all they need right here to show that false light and aiding and abetting in a retaliation campaign are never going to survive in New York. Not even if she stamps her feet and says apply California law. New York just doesn't do this. We've got a couple more word puzzles here. We have some Latin, Ipse Dixit. What does that mean? The direct translation is he himself said it. It refers to an assertion that's made solely because the person in authority said so. And they said so without any supporting evidence or reasoning. So we'll see this to criticize arguments that rely on the speaker's own authority rather than objective proof or analysis. So here we see Einstein with an obviously wrong math problem, and we're just supposed to take his word for it. He doesn't show his work or use any proof that the answer to this problem is 6. We know the answer to the problem is not 6. So these kind of statements, they lack in the necessary foundation to be persuasive, whether it's in a document or oftentimes it's used referring to court. You'll see it to criticize an expert witness, for example. So if an expert witness comes and he gives all of his credentials and he sits down and he tells the jury, this is how it is. In my expert opinion, blah, blah, blah. But then he gives no explanation for the methods that he used to lead to that blah, blah, blah conclusion. And it maybe doesn't seem to be a logical conclusion. Opposing counsel would tell the jury and probably even ask the court to strike the testimony because it's not founded by supporting evidence. So basically it's a because I said so. And so Babcock's here saying this is what Blake Lively's team's doing. They're not able to prove this by actual case law. So it's a because I said so. It's a trust me, bro. And so that's why he's saying in her argument, she's ignoring her own allegations. All of the ones he just showed that were unquestionably defamation. That neither the false light claim nor the FIHA aiding and abetting claim fall under the defamation exception. These are all about reputational harm, about a supposed smear campaign. That's the whole basis of her complaint against Jed Wallace. And she's saying it's not a duck. It's not sound in defamation. She says false light and aiding and abetting don't fall under the defamation exception. And it's absolutely absurd that they think that they're immune to these rules. These rules couldn't be more clear. Also, her team never seems to tire of quoting the wrong case law or case law that just doesn't support what they're saying. And they did it here again, citing Finley. But as Mr. Babcock skillfully points out, this case did not involve a FIHA claim first off. Not only that, it actually reiterates Babcock's point that determining whether a claim sounds in defamation, it is the reality and essence of an action that controls and not its mere name. So it doesn't matter what you call it. It's the reality of the claim and the essence of the claim. And in this case, they're about her reputation and therefore their defamation. He referred to docket 715 where she makes this claim. And this is where she says, neither the false light claim nor the FIHA aiding and abetting claim fall under the defamation exception. The reasoning she gives? Defamation includes the torts of libel and slander. And says, we're not trying to rename the cause of action as something other than defamation. And then says that Blake hasn't sought to premise her false light claims on any allegedly defamatory statements or alleged facts in support of her false light or FIHA aiding and abetting claims that are really defamation. This is accordingly not a situation where her claims rest on defamatory statements or where she's disguising defamation claims as claims for other torts. Because this is a case in which Miss Lively's false light and FIHA aiding and abetting claims are genuinely not duplicative of an unpled defamation claim. Miss Lively's FIHA aiding and abetting claim is not a cause of action for defamation of character, nor does it sound in defamation. So the first case they quoted actually supports Jed Wallace's side, and then they quote a second case that's out of California. But California doesn't have this rule like New York does. California recognizes false light. So any decision made in California is not going to help Blake's case here. But rather than supporting this, And this is why they call it an Ipse Dixit, because there's no case law, because it doesn't exist. It's just a because I said so. So here's how he backs up those claims we just read. They're like, it's not defamation. The Wallace defendants aided and abetted the other defendants' campaign of retaliation. What is the campaign of retaliation? It's the smear campaign. It's defamation. It's so stupid. And then they try to stretch it a little more and say, well, this aiding and abetting, it was more than boosting negative narratives. It was also providing advice and counsel to the Wayfarer parties, strategizing with them on the conduct of their retaliation campaign. So they're saying this doesn't sound in defamation. It's not defamation. It's defamation. We just saw New York recognizes these kind of retaliation things, these negative narratives, these reputational harm, all fall under defamation. So here we have this New York attorney writing this. But basically, it's the only defense that he can make. Now, in this Findlay case that he cites, the First Department terminated personal jurisdiction under New York's long-arm statute because the plaintiff's interference claim was essentially defamation. The court stated, courts must look for the reality and essence of the action and not its mere name. So here we see the application of exactly what we read. If it looks like defamation, New York considers it defamation, even though it was styled as a tortious interference. So the very case they cite supports Wallace, and the California one is completely irrelevant because they recognize false light. Now, he also says the reputational injury that she seeks to redress through her FEHA claims, that she misses the point with this too, because it's a reputational injury, not the manner in which the defendants are alleged to have aided in any retaliation campaign. It's the injury, the harm. And so he says her claims against Wallace are indisputably sound in defamation, and she cannot predicate jurisdiction on this rule. And if you look at Michael Gottlieb's document, it is absolutely filled with cases in California. Almost exclusively. There's one from Illinois and one from Arizona, and the rest of them are exclusively California. This is a New York attorney, and even he can't find one single New York case to support this argument. And remember last video I told you I couldn't find any, so now I don't feel bad because he couldn't either, because you better believe if he could have found one, he would have used it. But it doesn't exist because they don't do that in New York. So it doesn't matter how many cases he cites from California. New York is not going to apply California law because they can't. They don't recognize these other torts. They all fall under defamation based on the actual harm. And as you see in this tiny little footnote, he posts so many cases in New York, and look what they all say. Sounded in defamation. One after another after another. They simply do not recognize it. So these claims are not going to survive. Nor will any of the FEHA claims, because they're not going to recognize California law. Her case is literally falling apart. And at this point, you can blame her attorneys, who are happily taking her millions, but have not guided her in the best way. They really should have said, Blake, I know you want to do this in New York, but for all of your causes of action, for your chance at 47.1, California law suits you much better. But they didn't, and so here we are. So the next gymnastic they tried to do to bring it under jurisdiction of 302A1 is to describe Jed Wallace as an agent. And reading through that document, it was so nonsensical. It was so nonsensical. The Wayfarer parties happened to be in New York for the premiere and for the promotions, as I said earlier. While they were there, Melissa Nathan was contacting Jed Wallace. They hadn't hired him yet, mind you. But they were talking. There was a price quote, I believe, during this time, or at least that's what Blake's claiming. And so they're trying to say that business was conducted and that it was a conspiracy, and so he was an agent. And so we see the rule. It does say under A that acts which are the basis of jurisdiction. As to a cause of action arising from any of the acts enumerated in the section, a court may exercise personal jurisdiction over any non-domiciliary, or his executor or administrator, who in person or through an agent, and then it lists the actions. So they're trying to say, well, through an agent, since he wasn't in New York himself, they can't put him there. So they're saying by proxy, by having these conversations with Melissa Nathan, that was him transacting business in New York, even though he wasn't in New York. Now, there's a huge difference in specifically going to New York to conduct business or perform a transaction and just happening to be in New York for some other reason. And through the course of this conversation, Melissa next goes on to Chicago. So the entire transaction, if they want to call it that, doesn't even fully take place in New York. But let's humor them and say, through an agent, Wallace should be permitted through the acts of a co-conspirator. And so Babcock has actual New York law on his side, where he quotes a case in the Southern District, QBE Americas versus Allen. In this case, the court rejected the same argument that Blake is trying to make, when the court said it requires an agency relationship in which the purported agent acted purposely in New York for the defendant's benefit and with the defendant's knowledge. This was just a conversation that happened in New York, like I said, because she was in New York at the time. It wasn't an act that had to take place in New York. She didn't go to New York for some specific action to take place there. It just happened to be where she was at the time. They needed to hurry and get Jed on board, and they weren't home in California at the time. That's all it was. They furthered the argument by saying that this rule is talking about a specific agency relationship where the actor is an in-state actor who operates at the behest of a non-New York resident, and that they must have acted in New York as agents under the control of the Wallace defendants as their principal. They quote more case law for that. But Blake's claim is the opposite. She's saying that the Wallace defendants are agents of the co-conspirators. They're agents of Melissa Nathan. Well, that's backwards, so it doesn't apply. She's saying Melissa Nathan and the Wayfarer parties hired the Wallace defendants and controlled the Wallace defendants' activities. It's such a bad application of law. And so this case they cite, Sachs, jurisdiction did not exist where the non-domiciliary defendant acted at the behest of the alleged in-state co-conspirator. Another fail. And then the footnote goes through, again, directly from Blake's complaints, that Wayfarer and Baldoni retained Jed. Tag engaged Jed. Ms. Nathan helped the Wayfarer parties retain Jed. Tag engaged Jed. Tag retained Jed. Miss Abel and Miss Nathan directed Jed to take serious action on the social side in response. Miss Abel was calling Mr. Wallace to take action. So clearly Blake's allegations do not match her argument here. And I say again, Blake, everybody hates you. These people are steering you wrong and taking millions of dollars to do it. They cannot even keep their arguments straight here. And time and again, the Wayfarer parties and the Jed Wallace parties call it straight out. Point 3. These claims do not arise from the transaction of business in New York. And Jed Wallace was never in New York in person. The agency relationship is absent. They can't attribute these transactions to Jed because of the things they've already shown. Quote, more case law in New York. Absent facts establishing the requisite agency relationship, the transacted business element could not be plausibly alleged. And even if they could, none of the co-conspirators actually transacted business in New York. How do we know that? Because transacting business means that a party purposefully avails itself of the privilege of conducting activities within the forum state, thus invoking the benefits and protections of its laws. But the only transaction that Lively specifically points to is this trip. She was there not to conduct business with Jed Wallace, but to promote the film. As Wayfarer's PR agent, it was their duty to be there, and these were press appearances and attendance at the film's premiere. It's a place she had to be, and she also had to deal with handling communications with Jed. These two are completely unrelated to each other. This does not constitute transacting business. More case law. Hammond versus Alpha, the mere solicitation of business within the state does not constitute the transaction of business within the state. And in that case, attendance at a trade show in New York did not constitute transacting business. And in that case, it wasn't just attendance, but that visit could be used to the advantage of that particular defendant. So it was even a stronger case. It was still denied. And then he's saying, even if you could stretch it and say attendance at these events constituted transacting business, Blake's claim against the Wallace defendants does not arise out of these transactions, that none of her allegations of wrongful conduct that she claims that they did took place during these events, and that in her FEHA claim, there's no nexus between any New York transactions. She admits in that same document that her retaliation and aiding and abetting claim is premised on California-based conduct, and says that the retaliatory scheme was all carried out by California-based persons in California. This is another big mistake her attorneys made, because the reason there are pages and pages in that document referring to California is because Blake said, okay, if it doesn't fall under New York, it still shouldn't go to Texas. It should go under California. And then Gottlieb went about writing those pages and pages, describing how it's attached somehow to California. She has contradicted herself, and they can now use it against her to say she admitted nothing happened in New York. So her attorneys have messed things up for her again with this. Part C, the conspiracy-based theory also fails. Even if the defamation exception did not apply, and I love this little narrator voice thing they got going too, which it does, fails to allege facts supporting a conspiracy-based theory. So for the purposes of applying this long-arm statute, in order to place Wallace in a conspiracy, Blake has to allege specific facts, that he had an awareness of the effects in New York beyond her post, Blue Jean Baby, New York Lady. I mean, I know that is like the best proof you could ever have, but still. 2, the activity of the co-conspirators in New York was to benefit the Wallace defendants. And 3, the co-conspirators acting in New York acted at the direction or under the control or at the request of or on behalf of the Wallace defendants. We've already seen all of those crumble. So in spite of Blue Jean Baby, she's not able to allege facts showing that the Wallace defendants were aware of overt acts in New York. She uses things like email timestamps, area codes, Instagram posts, and she never alleges, because she can't, that Jed actually saw those timestamps or area codes, much less that he understood that that's what they meant, that it was some kind of amazing proof that Blake was in New York. Instead, what she says is that anyone engaged in passive observation of the social media environment would have been aware of these posts. He saw me in my blue jeans. He knows I was in New York. This is not a reasonable inference. It's pure speculation that fails to satisfy her burden, because this is her burden to prove, specific facts warranting the inference. She cannot prove that he knew she was in New York, or even that Melissa Nathan was contacting him from New York. And of course, more cases in New York. Mere speculation is insufficient to withstand a motion to dismiss. One of her arguments was that the phone registered Eastern Time Zone. How many states do we see here that are in the Eastern Time Zone? Seeing Eastern Time Zone on a timestamp is not proof of anyone's location. They could be in any of these states and have the same timestamp. When I told you it was mental gymnastics, I meant it. And then they said that the Wallace defendants have not argued ever to remove themselves from the conspiracy. And they're like, yes, we have. In docket 649, exhibit 2 on pages 5 and 6. What did they say? They said there was no conspiracy to remove themselves from. Is that not denying that they were part of a conspiracy? And now there's this involvement, these accusations that they were involved in the creation of a website, and that creating that is a substantial overt act in New York. And they say even if we were involved in that by Blake's own admission, these were materials filed in a prior lawsuit and thus are not actionable. And even if they were, there are no allegations that the website had any connection to New York. Part D, another reason it fails. In order to satisfy this rule, she had to allege facts showing, and these go back to the chart that we had, including the one drop-down qualifier that there has to be substantial revenue. They say that Blake has not and cannot reasonably infer that the Wallace defendants expected there to be New York consequences. She points to the $90,000 as being revenue. Now, even if they could get through all of those other qualifications and came down to this, it has to be substantial revenue. And he's saying, in this case, New England Laminates versus Murphy, it failed because an out-of-state corporation derived 4% of its revenue from New York. And that did not meet the substantial revenue standard. So he says, you don't know how much revenue my company makes. You don't know if $90,000 is substantial or not. It might be like this case, 4%. It's not substantial. So you haven't proven this. Guys, I think I'm in the wrong business. If 90,000 is not substantial, wow. And now we're kind of summarizing. As explained, there are no factual allegations supporting the reasonable inference that the Wallace defendants were aware of the alleged co-conspirators' presence in New York, or that they took any act in furtherance of an alleged conspiracy while in New York, but rather they were blindsided by the contacts with New York. Basically, he didn't even know they were in New York. and that exercising this jurisdiction over him goes against due process. He says she doesn't even address the most significant relationship test. She doesn't dispute that the laws of jurisdiction bar her false light claim, and she claims that California law doesn't require her to plead the elements of a defamation claim in connection with her false light claim, and they say that's what federal courts analyzing California's false light claims have required. We saw that in the jury instructions, didn't we? The mere fact that Lively has not alleged a defamation claim against Wallace defendants does not excuse her from pleading the elements of a defamation claim in connection with her false light claim. And it shows multiple cases in the Northern District of California, says where plaintiffs did not plausibly plead a claim for defamation, their false light claim necessarily failed, and that plaintiffs are required to plead defamation elements in connection with the false light claim, even though plaintiffs did not assert a standalone defamation claim. Like I said, we saw that in the jury instructions under California law. He then says that her admission that FEHA does not apply to non-residents employed outside the state when the tortious conduct did not occur in California is fatal, because she alleges no tortious conducts that occurred in California and plainly predicates her claims against Wallace defendants on purported New York-based overt acts. Even if the actions by Wayfair were discriminatory, there are no allegations that the Wallace defendants knew that, or knew that it was for purposes of retaliation or harassment. They say she failed to adequately plead a FEHA claim, and that because her false light and FEHA claims are fatally infirm, so too is her civil conspiracy claim. And so you see them all look like they're about to fall away, as they did once before already. And it really makes me wonder, had the Wayfarers filed any motions to dismiss any of the causes of action, what would have happened to them? And then we have a delightful conclusion that Blake has retreated not only from her primary conspiracy-based jurisdictional theories, although she puts up a game front, but despite repeating verbatim large swaths of her second amended complaint, because it really was just a repeat, there were a few added parts about Jed, nowhere mentioned is the previously pleaded winky-faced emoji, nor has she clarified the post which Lively claims the Wallace defendants must have seen and understood. It depicts Lively under the caption, Blake Lively at Blue Jean Baby, New York Lady, which anyone who has listened to Elton John or watched the movie or seen the play Almost Famous knows it's not New York Lady, but LA Lady, the address Lively used when she sued Wallace in Texas. I love their way of getting these little jabs in. We would concede that the Blue Jean Lady, wherever found, was in fact a seamstress for the band. But with all that, the motion to dismiss should be granted. We agree, Babcock. Thank you for this entertaining and wonderful filing. These are what we need at this point when we're all so exhausted. I also have a bunch of cases that I had looked up when I was reading Gottlieb's filing before this one came out, but for the sake of time, I'm not going to add them on here. I want to do them separately just to show, like I did with her false light claims against Wayfarer, what has actually happened in the courts to cases similar to hers, because that's the biggest indicator for how these are going to fall for her. Thank you so much for joining me tonight. Hopefully I'll get back to getting more out to you. Thanks again to all my mods, and I hope you have a great night.